Thank you. All right. Welcome, everyone. Thank you so much for joining us this afternoon. This is the Harvard Environmental Law Review Symposium on Climate Change Regulation under the Clean Air Act. I am Genevieve Parshall, one of this year's editors-in-chief of the Harvard Environmental Law Review.
I'm Samantha Caravello, the other editor-in-chief of this year's volume.
So today's panel will focus on the Supreme Court's June 2014 decision in Utility Air Regulatory Group versus EPA. The case was a critical case for the Obama administration's efforts to combat climate change, in which the court largely upheld EPA's authority to regulate greenhouse gas emissions from certain new and modified sources of air pollutants. Today's panel will explore the opinion's implications for future climate regulation, including EPA's Clean Power Plan. Before we get started, we would like to take a moment to thank our generous sponsors for making today's event possible, including the Milbank Tweed Conference Fund, the Harvard Law School Environmental Law Program, Green Living Program, American Constitution Society, and Environmental Law Society, as well as Themis Bar Review. Please also note that today's panel is being recorded and will be made available online after the event.
Now it is our pleasure to introduce the panel moderator, Carrie Jenks. Carrie is a senior vice president at MJ Bradley and Associates, where she provides strategic advice on energy, climate change, and air quality issues to clients. She advises companies on the business implications of regulatory and legislative proposals and works with clients to engage with state and federal policymakers. Prior to joining MJ Bradley and Associates, Carrie was an associate in the environmental groups at Wilkie, Farr & Gallagher in Washington, D.C., and at Goodwin Procter in Boston. Carrie holds a Bachelor of Arts degree from Harvard College and a JD degree from the Georgetown University Law Center. Thank you, Carrie.
So we'll just introduce the panelists and then turn it over to the panelists to give a brief description of their papers. So Professor Buzbee is a professor of law at Georgetown University Law Center. He joined Georgetown from Emory Law School, where he's a professor at law, directed Emory's Environmental Natural Resources Law Program, founded and oversaw the Turner Environmental Law Clinic, and co-directed Emory's Center for Federalism and Intersystemic Governance. Professor Buzbee is also a founding member scholar of the Center for Progressive Reform, a Washington, D.C.-based regulatory think tank. He teaches environmental law, administrative law, legislation and regulation, and seminars are environmental, regulatory, and constitutional law subjects. His most recent seminars explore the art of regulatory war. Professor Freeman is the Archibald Cox Professor of Law and founding director of the Harvard Law Environmental Law Policy Program. She's a leading scholar of both administrative law and environmental law and has written extensively about climate change regulation. Professor Freeman served as the White House Counsel for Energy and Climate Change in 2009 to 2010, where she contributed to a host of initiatives on renewable energy, energy efficiency, transmission policy, and oil, gas drilling, as well as the administration's effort to pass legislation placing a market-based cap on carbon. She was the architect of the president's historic agreement with the auto industry to double fuel efficiency standards, which launched the administration's greenhouse gas program under the Clean Air Act. Professor Freeman's areas of interest include administrative law and regulation, environmental law and policy, climate change, energy law and regulation, executive power, delegation, principal, agent theory, and governance theory. As an Emmett and Frankel Fellow, Megan Herzog researches law and policy solutions to the climate change crisis and other environmental issues for the Emmett Institute on Climate Change and Environment. Megan also teaches ocean and coastal law policy and works closely with UCLA's Law's Frank G. Wells Environmental Clinic. Her research interests include coasts, oceans, climate, disasters, energy, and the intersection of natural resources and human rights. Her ongoing projects include supporting local governments in sea level rise, adaptation planning, advancing national climate change policy, mitigating marine plastic pollution, promoting environmental sustainability in Los Angeles, and examining the role of regulators in clean energy innovation. Prior to joining UCLA's law faculty, Megan Herzog served as a public interest law fellow at the Environmental Law Institute in Washington, D.C. Professor Oren teaches courses in environmental law, administrative law, legislation, and property. He is an expert on federal Clean Air Act and has written extensively about the Act's attempt to protect clean air, to induce people not to drive to work, and to set air quality standards that will protect public health. Prior to joining the Rutgers faculty in 1984, Professor Oren clerked for the California Supreme Court, practiced litigation at Schiff, Hardin, and Waite in Chicago, and served as the assistant counsel for the Subcommittee on Health and Environment, the Committee on Energy and Commerce in the U.S. House of Representatives, and was a consultant to EPA, Office of Air and Radiation. He has served on the National Research Council committees on visibility, hazardous air pollutants, and news source review, and helped write the reports issued by those committees. He teaches property and administrative law in addition to environmental law. Professor Lazarus is the Howard and Catherine Abel Professor of Law at Harvard, where he teaches environmental law, natural resources law, Supreme Court advocacy, and torts. Professor Lazarus has represented the United States, states and local governments, and environmental groups in the U.S. Supreme Court in 40 cases and has presented oral argument in 13 of those cases. His primary areas of legal scholarship are environmental and natural resources law, with a particular emphasis on constitutional law and the Supreme Court. Prior to joining Harvard, he was a professor at Georgetown, where he founded the Supreme Court Institute. So let us turn it over. We'll start with Professor Buzbee, and each panelist has about 4 to 5 minutes.
Interject one thing is, since HLS is the host of this, the students have done such a wonderful job. So just to say thank you to the student organizers. You guys have done terrifically in putting together the symposium issue, which was kind of a Herculean editing effort because we all are very particular about our work. Really, congratulations to the Law Review. And you should know that the experts here, and we're missing Tom McGarity, who unfortunately had lost his father and so couldn't come give his paper, but he really regrets that he had to miss this because he was really looking forward to it. And including Tom, you have a really stellar, impressive, as you could tell from the credentializing that just went on, a group of people with really deep expertise in the Clean Air Act in particular and environmental law more generally. I mean, Craig Oren, everything I know about the Clean Air Act, I kind of learned from reading Craig Oren's comprehensive articles. Buzbee and I go way back when we were really young. We were fun, and we did stuff together, and I mean, academic-y stuff. And you know, Megan is associated with a terrific program at UCLA that I know very well, and they're excellent, doing superb work. And you know, Richard is the nation's leading expert on the Supreme Court and environmental law. So you really couldn't have put together
Ricky.
And Ricky isn't here. Pardon me. Ricky isn't here. A leading scholar, especially of the kind of student of law and economics and economic approaches to environmental regulation. So you just sort of put together a really, really strong group of people, and we're really proud to have you all here. So now I will let Bill talk.
Yes. Well, actually, I think Carrie was going to describe the case a little bit, so we can all focus on our critique of it, if that's okay with everybody. Okay?
And I'll do my best, and please correct me if I get something wrong. But I work with a lot of utility companies that cared about this rule a lot. So my perspective is more on the practical implications for them. So EPA had the permitting program for major sources, and so it's the PSD program. And the question happened once EPA decided that they had to regulate major sources under the Clean Air Act under this PSD program. The question is, does the traditional thresholds, 100 and 250 tons per year, apply, which makes sense in the air quality standards, the traditional NAAQS, but doesn't make sense in greenhouse gases necessarily. And so EPA issued the timing rule saying that they had to regulate major sources once the tailpipe rules went into effect. And then they released the tailoring rule, which changed when the 250 and 100, they raised those thresholds upward, which made more sense in the major source categories. EPA lost that rule in the DC Circuit, and it got appealed to the Supreme Court, where it was upheld. And Scalia wrote the majority opinion. And so I think, my opinion, it took people off guard that Scalia was able to write the majority and get the majority and support EPA at the same time. The way they played that out is that they disagreed with EPA on that it would trigger it regardless, and the tailoring rule, they said you can't have it be, they couldn't have those thresholds, but they would say if you are triggering greenhouse major PSD permitting, then you can also look at greenhouse gases. And that's the way that it's being implemented now. But I'm sure you can say it more elegantly than I did.
Well, that was very succinct. And really thanks so much to Genevieve, Samantha, and Cecilia for putting this together, and then Jody and Richard and everyone else for being here. The editors of the journal are very smart, I think. The decision came down, they decided to try to get a group of us to propose succinct papers that would kind of have a narrow focus, and then I guess collectively would create an interesting ensemble of articles. So So my guess is what we're going to do in our critiques is probably be like kind of painters doing different part of a canvas, because none of us with about 5 minutes are going to describe everything in our papers or everything in the decision. So I'll just try to kind of give the heart of my critique. As especially you students would know, Justice Scalia is famous for many things. A man of great humor, a justice with strong opinions, but he also is the most ardent advocate, very strong advocate of certain techniques that he claims have certain virtues that should be obeyed by justices and judges across the land, and then also sometimes talks what he views as the essence of what makes law good and what is not law. And so when this decision came down, which, as Carrie alluded to, the opinion was written by Justice Scalia, but he actually was writing in the end for two very different majorities. Part of it skewering EPA, really castigating EPA for outrageous overreach and other strong language, and then another part upholding what EPA did as justifiable under the statute. And so I thought, okay, well, this is a very high-stakes case involving EPA's power to regulate greenhouse gases, and I was kind of interested in just using this as a case to see how did Justice Scalia do measured against his own statements about what law should do and what judges should do. And the short answer is not very well. But I'll quickly just summarize. So basically, Justice Scalia is most famous for writing about textualism, and his view is judges and justices really should base their opinions on the ordinary meaning of a legislative text and should not look at legislative history, should not engage in intentionalist or purposivist modes of interpretation, but should read a text according to its fair and ordinary meaning, also informed by context and structure. Okay. In other areas, he's been a very strong advocate of deference to agencies under the Chevron case, saying that for courts to get involved, either applying standardless forms of review will lead to judicial overreaching. And in several other areas, he's made the same point. And he wrote an article when he was, I can't remember, I think he was on the D.C. Circuit, wrote an article called The Rule of Law is the Law of Rules, I believe was his exact line. And he basically said, if law is going to work, it has to be determinate, predictable, and constraining. So, in the UARG decision, the Utility Air Resources Group decision, here he is drafting this opinion, and the first part of the opinion was dealing with several kind of constraints. You'd had two major Supreme Court decisions upholding EPA's power to regulate greenhouse gases, Massachusetts versus EPA, and a case called American Electric Power. And those two cases were quite clear and actually had some very broad language about EPA's power. And so you had those as a powerful precedent about EPA's authority. And then you also had actually EPA approaches to this program called the PSD program dating back, for the most part, to 1978 and 1980. And then subsequent legislative action that had not interrupted that approach that EPA had taken for a long time. And so what did he do in his opinion? Well, he starts off and very quickly just says more or less EPA, and I guess maybe the Supreme Court itself previously had been wrong, that EPA was not so obligated to regulate greenhouse gases, and basically says you have to look at every single provision of the Clean Air Act and decide whether to regulate it. And so, and in that little bit of language, he jettisoned a substantial part, as others will talk about more, I suspect, having read their papers, jettisoned a substantial part of the strongest core of the Massachusetts versus EPA case. And then the American Electric Power case that had strong language talking about EPA's power to regulate stationary sources of pollution, and that language also was questioned in the UARG decision. So two major precedents have been undercut, which itself is contrary to judges or justices who talk about there being fealty to the rule of law, predictable, stable law. Now, I'll jump ahead. Because his first part, he castigates EPA and says it overreached, and then later on says EPA had this power to regulate PSD, or regulate sources under the PSD program if they were already subject to it. EPA substantially was able to continue regulating as it has. But I'll just end with a few comments. At the very end of the decision, he proceeds to drop, well, actually two different places, a whole slew of unusually strategic and politicized hints about what he thinks EPA can and should do in the future, or potentially other judges should do when reviewing EPA actions. And so, first, very importantly, he looks at a case called the Brown and Williamson case, which is a case saying that agencies should not be basically construed to have power to take under major questions. There's different ways to characterize it, but it's an anti-regulatory canon of construction that questions broad agency claims of power, and he uses that in his language in a few different places to say that EPA in this instance was grabbing power that it really should not have grabbed. And it's not really clear that the canon fit here under its previous constructions, and so it's arguably dicta for you Supreme Court parsers. Nevertheless, this case has been substantially strengthened, and you can be sure it will be used in subsequent cases. In fact, right away, UARG and its construction of Brown and Williamson appeared in appellate court briefs within about a week of the decision because it's so important. But then he goes on, and in several passages, and I'll stop. He proceeds to talk about how EPA, the intersection of environmental law and energy law, and very much questions EPA's power to deal with environmental pollution in a way that would affect essentially energy regulation. This also was unusual, really dicta, reaching out, because this was not squarely presented. And yet, in several passages in the text and footnotes, he basically plants the seeds for future attacks on EPA regulation. And so my take in the end is that it's either poorly done textualism, it is not really rigorously looking at the statute, it is not consistent with a stable rule of law, and then the most anti-regulatory and indeterminate of statutory canons, this Brown and Williamson canon, is used to substantially undercut EPA power. So I'll stop there.
That is an absolutely perfect segue to my paper, because mine focuses on the implications of just these passages and the hints that are dropped, which I call legal improvised explosive devices that Justice Scalia and arguably the votes that went with him, the 5 justices who signed on to that language, have now planted, which are clearly awaiting the new, very far-reaching, ambitious Clean Power Plan, the new rule to control greenhouse gas emissions from the existing old, dirty coal-fired power plant fleet of power plants. So I think this question is really the heart of my piece. I start by saying that the UARG case, when it came down, was perceived quite generally as a victory for EPA, even though EPA lost an important issue in that case. That is, it lost the issue just discussed, that the court found that, quote, the language "any pollutant" doesn't include greenhouse gases necessarily. It's a quite stunning interpretation on its face. And in this case, it didn't include greenhouse gases so that they could not trigger sources into coverage in this particular program. But EPA was quite happy because that avoided the issue of regulating many, many thousands of sources and avoided many millions of sources under the Title V permitting program that also would have been affected. And it saved EPA all the administrative burden, and yet they were still left with the power to regulate. As we heard at the setup, they were still left with the power to regulate greenhouse gas emissions from sources that were triggered in the program anyway. And that represented an overwhelming majority of greenhouse gases. So the result from UARG was actually pretty much a total win for EPA in the practical sense. Also, most of the case was won originally when the Supreme Court granted cert only on the narrow issue and not on all the other issues that were being challenged, including the endangerment finding that undergirds all of these rules and the tailpipe rule controlling emissions from the transport sector. And all that, nobody granted cert. I mean, not nobody. The Supreme Court didn't grant cert. So the case was a winner right out of the gate. So when it comes down, the sort of reaction from the environmental community and the community interested in climate change and the government was joy. And it was spun in the press as a fantastic victory. And the New York Times and everybody else had stories about how EPA won. And all I could do in my office was just massage my temples because I was reading this language in the majority opinion that I understood to be warning shots across EPA's bow about overreach, the invocation of Brown and Williamson, as Bill said, to raise the specter of Brown and Williamson, to say that on some matters of great political, social, and economic importance, we will not read ambiguous language to let the agency assert regulatory authority. Instead, we will send it back to Congress to speak clearly. Nobody had been spending a lot of time invoking Brown and Williamson and the major questions canon that it represents, send it back to Congress. And so when Justice Scalia in the opinion wrote, EPA's interpretation, meaning treating any pollutant as including greenhouse gases for this program, EPA's interpretation is also unreasonable because it would bring about an enormous and transformative expansion in EPA's regulatory authority without clear congressional authorization, where an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy. We typically greet its announcement with a measure of skepticism. We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. Well, that's just rehash, and you might not care about it much, unless you were anticipating EPA proposing a rule to regulate the power sector, in which it discovers, in a, quote, arguably, at least for some, for critics, long extant statute that arguably, at least for critics, nobody had ever heard of, 111D, and located in this provision the power to regulate the existing fleet of old, dirty, coal-fired power plants and set rules that would establish targets for every state in the country, those targets representing improvements in carbon emissions that would require in total a 30% reduction in emissions by 2030, that EPA would position and locate the authority to set those targets for every state in the country, and to essentially do that based on a method of analysis that estimates what each state can do by displacing coal-fired power with other kinds of power and energy efficiency. The idea that EPA would locate the power to set targets like this in the Clean Power Plan with the broad sweep that this involves in a provision 111D that nobody had ever heard of might fit into the category of the kind of thing Justice Scalia is talking about when he says that he is skeptical about enormous and transformative assertions of legal authority. So I read these passages as a clear indication that at least 5 justices on the court were as skeptical as this language sounds about asserting authority without clear congressional authorization. And it made me worry. And so I called my piece, Why I Worry About UARG. Not because the case, to me, is a big threat to Mass versus EPA, although Bill's right. I think it does cut back on Mass versus EPA's essential holding that greenhouse gases are pollutants, period. Now they're pollutants, maybe. There's an upside to that, potentially, because EPA can now defend its decision not to set a national ambient air quality for greenhouse gases by arguing greenhouse gases aren't a pollutant for purposes of the NAAQS program. So it has an upside, but it's widely perceived to be an erosion of Mass versus EPA. But that's not my problem. My problem is the legal IEDs. They're awaiting the Clean Power Plan. And so the piece discusses in some detail what the power plant proposal purports to do, these targets, as I mentioned, for states, the methodology EPA uses to set those targets. And I'll give you just 30 seconds of what I worry the most about. And that is that the language of 111D, the provision authorizing this rule, reads as requiring EPA to set performance standards. I'm paraphrasing and condensing. EPA to set performance standards, actually it requires the states to do so, but we're skipping that right now. EPA to set performance standards for sources. And EPA's methodology is setting performance standards for these coal-fired units by taking into account what can be done beyond the unit. That is, what can be done by investing in energy efficiency, what can be done by substituting natural gas for coal, what can be done by leaving nukes in place, nuclear power, what can be done by investing in renewables. And so EPA is counting a lot of measures that can be taken on the grid to reduce greenhouse gas emissions by displacing coal-fired power. And when the statute calls for setting performance standards for stationary sources, critics would argue that that means only measures that can be done at the site itself, at the unit itself, what we call inside the fence line. And so EPA is arguing that it has the authority to go beyond the traditional sort of understanding of performance standard, because the statute also says that a performance standard for this program means best system of emission reduction. And the EPA's argument is best system is the grid. Best system is everything. Best system is anything that you can do that would reduce greenhouse gas emissions at these coal-fired units, and that includes, because it's an interconnected network, all kinds of measures that can displace coal-fired power, including energy efficiency. And Richard and I have spent a lot of time giving presentations on this and talking about this. We could do it now in our sleep, I think, our presentation.
But we wouldn't make you go to sleep.
No, it's super exciting. But the concern, the why I worry about UARG is that the language about overreach and the language about putting too much weight on provisions of a statute that have been relatively unknown to this point, and the language about extending EPA's authority to areas of the economy that have this vast political significance, et cetera, all of that language does not bode well for a rule that is quite ambitious and bold and rests on an interpretation of best system that arguably is limitless. Arguably is limitless, because if anything that reduces emissions can be part of a best system, then EPA can count all kinds of measures that mean you turn the lights on less and your buildings have to be more efficient, and we don't need to be so warm by turning down our thermostat. So there's a legal argument that this is a boundless exercise of legal authority. I think there are good responses back. I won't take any time. Maybe in questions we can talk about. I think there are good responses. EPA has solid legal arguments for why it's definitely a reasonable interpretation of the statute. There's no question there are good defenses to mount. But UARG made me worry, because it sounded like 5 justices were already waiting in the weeds for the Clean Power Plan. And that's what my piece focuses on.
And is this one? Great. And that's actually a really good segue into our piece, because in our piece, Professor Ann Carlson and I also talk about the implications for UARG for the Clean Power Plan, which is the new existing source rule. And we propose that UARG shouldn't be considered separately from the other Clean Air Act blockbuster environmental law case that came out of the 2013 Supreme Court term, and that's EPA versus EME Homer City Generation. And in Homer City, the court upheld EPA's interpretation of the Clean Air Act under a different provision, but to protect a really innovative and ambitious emission trading program, which dealt with a really sticky pollution problem of cross-state air pollution, and so pollution from some states that were causing other states to suffer under the Clean Air Act. And so while these two cases might seem sort of in opposition, right, on one hand we have Homer, where the court deferred to EPA's reasonable judgment and upheld this really ambitious, innovative program, even though an argument could be made, and in fact the lower court found that the statutory text foreclosed that program. And on the other hand, we have UARG, where the court invalidated EPA's interpretation of the act as unreasonable and struck down something that seemed to have been compelled by the text of the Clean Air Act. These things seem sort of in opposition, but we think that when you read the cases together, there's a unifying theme. And the unifying lesson of these two cases is that context really matters in how the Supreme Court is looking at these rules and these interpretations of the Clean Air Act. And in fact, context may even matter if the statutory text itself points in an opposite direction. And so we think that the lesson for the Clean Power Plan is that context is going to matter significantly. And we think these two stories, the Homer story and the UARG story, are different options of ways that the court, if review of the Clean Power Plan should reach the Supreme Court, are two different options of ways that the court could view this new innovative program under Section 111D. So on one hand, in the Homer story, the court could look at the 111D rule and think that this is really a cost-effective and efficient and equitable way to deal with a really sticky pollution problem of reducing greenhouse gas emissions from the electric sector, where simple technology fixes are not likely to be the most cost effective or to result in the greatest emissions reductions, right? We have to think of the electricity sector as this interconnected and integrated grid that requires these special measures to reduce emissions, even looking outside of the fence line of the power plants. So the court could think of it that way. Or there's the UARG story, where the court could see this as a really enormous and transformative move by EPA to regulate under, as Jody mentioned, just a really historically little used provision, a vast sector of the American economy. And the court could see EPA as really overreaching. So we think that when review of this reaches the court, that what's going to matter is which of these stories are most compelling to the court. It's going to be more the contextual stories than really this fine statutory analysis of what the Clean Air Act does or doesn't allow, because we really think that UARG and Homer have signaled that the court is thinking about these climate rules in context. And we personally think that the Homer story is, on balance, the more compelling story for a way to think about the Clean Power Plan. But there are certainly indications in UARG that certain justices, and maybe even 5, are really looking skeptically at these sorts of innovative emission control programs. And so the challenge will be for EPA in its future efforts to finalize the rule and in the litigation that will inevitably ensue over the Clean Power Plan to really make this compelling narrative about the Clean Power Plan as more of a Homer story than as a UARG story. Yes, go ahead.
Hi, I'm Craig Oren. I'm very honored to have been invited here today. I agree with the holdings in UARG, but I question much of Justice Scalia's opinion on grounds that have really, to some extent, been mentioned already. Let me start with the ruling that greenhouse gases do not count in determining whether a proposed source needs a PST permit. Justice Scalia mischaracterizes the rationale of the D.C. Circuit in upholding EPA. Justice Scalia says the D.C. Circuit held that greenhouse gas emissions can make a source need a permit because greenhouse gases are within the Clean Air Act's definition of air pollutant. Neither the Court of Appeals nor EPA said any such thing. What EPA really argued was that the term air pollutant, as used in the PST program, means all pollutants regulated under the Clean Air Act. And since greenhouse gases are controlled under the Clean Air Act's motor vehicle program, therefore EPA said we had an obligation to consider greenhouse gases like any other air pollutant regulated under the Clean Air Act. And so the real question was whether EPA was right in saying that its interpretation was required by the Act, and if not, whether EPA's interpretation was reasonable. That is, had the agency passed the Chevron test. Justice Scalia, though, virtually ignores those questions. Had he done so, had he addressed those questions, he would have had to have decided whether the term air pollutant in PST could or did mean something less than all regulated air pollutants. That was a question the D.C. Circuit had faced, but Justice Scalia's opinion does not. In fact, he misstates the Chevron test in a manner that would be embarrassing on an administrative law exam, even though, of course, he is a Harvard graduate, okay? Now, Justice Scalia does get it right, I think, in insisting that the agency follow the words of the statute rather than try to rely on invocation of broad purpose. It is hard to assign a single purpose to the Clean Air Act, just as the court had acknowledged 30 years ago in the Chevron case. And I think it would be a mistake to depart from the clear words of the statute. Much anti-environmental mischief could arise from ignoring the words of the Clean Air Act. On the other hand, Justice Scalia, as already mentioned, enunciates a wholly unnecessary rule that statutes can't be interpreted to allow new uses of regulatory language. I also agree with Justice Scalia's holding about sources that need PST permits because of their emissions of another air pollutant, what are called anyway sources. Justice Scalia said correctly that such sources need to control any significant emissions of greenhouse gases with the best available control technology, BACT as it's called. He follows the statute, which says clearly that PST applicants have to show that they are complying with the best available control technology for each, and I'll quote, air pollutant regulated under this act, regulated under the Clean Air Act. And because greenhouse gas emissions are regulated under the agency's authority to regulate motor vehicles, the control requirement applies to greenhouse gases. Justice Alito makes various objections, but as I seek to show in my paper, none of them have merit. The BACT requirement, as he says, not be a good idea, but it's hard to argue that it is absurd or impossible to implement. But then Justice Scalia spoils his opinion. He says that the statute's requirement for the best available control technology extends only to controls in the sources stack. There was no reason to address this issue. Moreover, Justice Scalia, that noted textualist, doesn't even cite the words of the relevant statute. He doesn't cite them because the words of the statute are opposed to what he's saying. And that leads him into dicta, which, as both Megan and Jody pointed out, undercut a very important program that EPA is undertaking to control greenhouse gas emissions from existing power plants, a program that we need because, frankly, existing sources of greenhouse gases, regulating them is a lot more important than regulating new sources of greenhouse gases. Thank you very much.
Poor Justice Scalia needs a friend. Does he not?
All right, I get to be last. My principal challenge in writing this essay was the same as it is today, and that is I had a threshold concern that I would say what other people were going to say. Particularly, I was very worried I would say whatever Jody was going to say, because we talk all the time, and so we tend to come to the same conclusions. So I thought I needed to have a different goal for this essay. One was to say something different than what everyone else was saying, and the other was to be provocative. So that's what I decided to do. The focus on my sort of thinking on this was why, because I sat there last June when this thing came down, and Jody and I were emailing back and forth as we found this language which was making us more and more unhappy.
And it was early.
Yes, it was 10:15 or 10:20 in the morning. And I spent a lot of time thinking about why this opinion was worse than I expected. Because actually, the outcome was exactly what I expected. How the court split the issue was exactly what I had anticipated. And not what I had hoped for, but what I had expected. And that is, the court would say that greenhouse gas emissions from new modified sources under the PSD program couldn't trigger the permit requirement of that program, but once a source was otherwise subject to that program's permit requirement, then greenhouse gases would be covered too. It just seemed like the most logical thing that this court would do. And I was all prepared when that decision came down and people started yelling about how EPA lost. I'd be saying, no, you got it wrong. Actually, I don't think it was the best outcome, but actually they won almost everything they wanted. So I was all ready to be out there saying that. And then what happened is the decision comes down, and it's what I thought in terms of the judgment. And Justice Scalia from the bench says an EPA won everything they wanted here. But then I read the opinion. And the opinion was much worse than the outcome. So I was completely flipped. Instead, it was worse than I expected, even though the outcome was exactly what I expected, rather than having to tell people it's better than they thought. So what I decided to do, looking at it, and it was bad for all the reasons Jody and others have talked about, all those worries, gratuitous statements, unnecessary language in it. You can write opinions different ways and reach the same outcome. You can write them, you have the same judgment at the end, you can write it along different pathways, narrow ways, broad ways, and the way he chose to write this opinion had all these landmines in it. So the immediate sort of cause of this was obvious. Justice Scalia wrote the opinion for the court, and he used his opinion writing authority for the court in full measure. And that's nothing, people do that all the time. I've often been the beneficiary of that. Justice Ginsburg wrote the court's opinion in AEP versus Connecticut. And she wrote in a way which the environmentalists lost, but lots of generous language in there for the future. So that kind of thing happens all the time. But this time Scalia had gotten the opinion, and he had basically taken full advantage of it. So I decided to think about, how did this happen? How did he get the opinion? Because I don't believe in Scalia luck on this one. So the question is, how did he manage to capture what is the most important thing you can have, which is the authority to write the opinion for the court? You can lose the opinion as you write it. You've got to write it in a way which keeps you have a lot of authority when you write it. So I looked at Scalia's assignment, what the factors were that led to Scalia getting the opinion assignment in the case, and I included a couple things. The first one is pretty uncontroversial, and the other one is a little bit more controversial. Now, to get it, he had to be assigned the opinion by the senior justice in the majority. And the senior justice in the majority for this one was Chief Justice Roberts. So Roberts had to assign the opinion the same way Roberts assigned the opinion to Ginsburg in the AEP versus Connecticut case. This time he gave it to Scalia. What was unusual with this case is Roberts only had 3 choices. In most cases, you have at least 5 people you could pick to write the opinion, because there'll be 5 in the majority. More often than not, the court's unanimous. He has 9 justices to pick from. This one he only had 3, because there were only 3 justices who were in the majority for all of the opinion, because it was a fragmented court. He had at least 5 for every part, but only 3 were for all parts of the opinion. So he had to pick himself, Kennedy, or Scalia, the only ones who could write the opinion for the court. That's a narrow group. And if you look at it, there's ways that the chief assigns opinions. And for him, like many prior chief justices, they believe strongly in equity. They do equal numbers per argument session. So they have about equal numbers by the end of the term. This has been long-standing with chief justices, the equity principle. And actually, so he could give himself, he could give it to Kennedy, or he could give it to Scalia. He really couldn't give it to himself because there was another case argued that same 2-week session called the Halliburton case, a securities exchange case, of far more importance to the Chief Justice than this one. He was going to assign himself Halliburton. He also couldn't assign so easily Kennedy this one because there was another case argued that same session called Hall v. Florida, involving the death penalty and the IQ tests for death penalty. That's right in Kennedy's wheelhouse. That's his opinion. He had written the other ones involving unconstitutional death penalty. He was going to write that one too, which meant both the chief was sort of out of it, and Kennedy was out of it. He could do it, but it would be hard-pressed to do it because he'd be giving themselves more than others. So I thought, okay, so that's non-controversial, how Scalia gets it from the chief. The more controversial part to me was, why was Scalia in the majority? Why was he one of those 3 in the majority? Because actually the way I read Scalia, and I read Scalia's attitude towards Masters the EPA, I read his oral argument questions in the case, I read him with dissent in this case. I read him with Alito and Thomas. But the only way that he could get this opinion assignment is by voting to split the baby and not to do a purist principle. So I think, my guess is he may have shaded his vote. He may have shaded his vote at conference in order to be one of the three, so he could have the opinion assignment, so he could write this opinion, which included all these landmines in it. Now the notion that a justice would shade their vote somewhat, not vote exactly how they always think, that's not that unusual, that by itself. Because justices all the time may decide, well, I think it's really important the court have a unanimous opinion here. I think it's important institutionally this to be unanimous. I may not agree with everything in here, but I'm going to sign onto it. So that kind of thing happens for good institutional reasons all the time. And we're not going to fight over every single part of this. It's important that there be a majority of the court here, that we don't have everyone writing for themselves a separate opinion. So I may not agree with everything here, but I'm going to go this way. So I get that. Just the fact you may have shaded your vote, I think that actually there may be some people who think that Breyer and Kagan did that in the Affordable Care Act case a few years ago, to sort of be with the chief on something. So people do those sorts of things for institutional reasons. What struck me here is that's not Scalia. Scalia is the kind of person who says middle ground, like split the baby, right? A middle-of-the-road position is for him roadkill, right? He is someone who prides himself on his principles and where they take him. That's been his signature for most of the time on the court. He can push it this way, he can push it that way, but he doesn't sort of compromise. And that's why you see Alito chiding him in dissent here. Because he says it's not, the word air pollutant isn't a greenhouse gas for the trigger, but the word air pollutant is a greenhouse gas once it's triggered. You can draw differences. I think the first one is anti-textualist. But once you make that move, the other one isn't that much harder. You already made that anti-textual move. But if you make that move, you join Alito and Thomas in dissent, you've lost the opinion assignment. And I think that what we see now with Justice Scalia is a different Justice Scalia than when he was first on the court. We have a Justice Scalia who at this point in his career is someone who is more interested in writing precedent, more interested in influencing opinions. When you're on the court and you're 48 or 49 or 50, you have a long-term time horizon about how you're going to influence the law and what you're going to do. When you're on the court and you're 78 or so years old, you don't think you're going to be on the court as long. And so you're more interested in influencing it while you can. And I think Scalia is now more of a player. He's more of a strategic player than he was before. Where I saw him do that transformation was actually not an environmental case. It was in 2007 term. It was District of Columbia v. Heller. It was the Second Amendment case. That's the first really significant Supreme Court opinion that Scalia wrote. And that was in 2008, and he went on the court in September of 1986. That's a long time. He's had tremendous influence, but not in writing opinions, because he's always been sort of picking his own thing. He's not been a player. In that case, he gets the opinion of the court. And he writes this very nuanced opinion, and he has qualifications and compromise in it, because he learned, if I want to be a player, if I actually have the opinion for the court, I'm going to have to qualify my voting a little bit at conference in order to get those opinion assignments. And I think that's what he did here, which is why I titled my article in part, The Unbecoming of Justice Scalia. And that is that I think it's a different Justice Scalia than we had before. It's a more strategic one, and I think very effective in this case.
Great, thank you. So I've got a few questions, and then we'll open it up to the audience for more questions. One question to start off, which is building on the theme that Professor Lazarus just started with, is one for Professor Lazarus, Oren, and Buzbee. I think all three essays discuss how the majority opinion diverges from Scalia's traditional approach. Professor Lazarus, you mentioned this may not be the first time, but do you see this as a signal that he is trying to roll back Mass versus EPA, and really driven by his opposition to EPA's greenhouse gas authority? And should we be further concerned that he was able to get 4 justices to sign on to his opinion?
Yes, I mean, I think one of the more striking things about the case is that you look at it, to keep his majority for the whole opinion, Alito and Thomas had to do a very peculiar thing. And that is, they dissented from the part of the opinion which said that once it was triggered, EPA could regulate greenhouse gases. They dissented from the conclusion, the threshold conclusion. But then Scalia, writing that part of the opinion, threw so much garbage in there to limit what EPA could do once they were regulating that actually he lost the votes, right, of Breyer, of Sotomayor, and Kagan. And he only kept his majority because Alito and Thomas said, we disagree with the premise, but we'll join that part of an opinion where we actually think EPA has no authority, but if they do, they can't do all this other stuff. That shows how far Scalia was willing to, he was pushing it as far as he possibly could in the case.
Yeah, just to give you a sense of it, since I assume you have not all looked at the opinion itself, it has 17 pages of the opinion or the majority talking about how EPA overreached. Okay, and so it's 17 pages that limits the previous greenhouse gas precedents, that does what I view as very kind of sloppy textualism or claim textualism, saying, look, the text just doesn't support this, and it brings in this Brown and Williamson canon to say EPA is claiming too much power in a new sort of way. So that goes on for 17 pages, and then it's 2.5 pages is where the 7-justice majority says, well, EPA can do most of this anyway. So you actually have 17 pages of it's not, these aren't like subtle hints. I mean, these are 17 pages of language all over the place that is very strongly anti-regulatory, and I don't think just for this. That is, it basically is saying to future administration and justices and judges in lower courts, yeah, you can look for this agency to do less, and you, a future president, can perhaps look at the same statute and do less on the greenhouse gas front than before. And so it is this kind of odd opinion where you have 17 pages that's in so many different ways setting the stage for future attacks, especially on the energy front, and then this limited upholding that is the immediate programmatic impact. But the bigger impact long term, as I think, as we all have been saying, is all of this limiting language.
There is a remarkable, from an administrative law perspective, declaration in this opinion, which is that it is reason enough not to adopt an interpretation that it poses an enormous administrative burden to adopt that interpretation. So it would therefore be this is under the Chevron doctrine, the famous Chevron doctrine, that when the statute's ambiguous, courts defer to reasonable agency interpretations. It's reasonable, therefore, for an agency to say, we're not going to adopt an interpretation that would foist a terrible burden on us. And that would be sufficient. That is a remarkable permission slip to do a lot less if you're an administration that doesn't want to regulate. So if this gets picked up on, I think this is really significant.
Just to give a quick historical context, Thurgood Marshall was very good at this too. I mean, Thurgood Marshall, when he was on the court, wrote some NEPA decisions for the court, which went against the environmentalists, but he got the opinion assignment. Berger gave it to him because actually under the equity principle, Berger had no choice but to give it to Marshall. And Marshall then went that way, and he wrote these opinions which ruled against the environmentalists, but was full of incredible pro-NEPA language, full of all kinds of great stuff, which the environmentalists then used in the lower courts. So it can work both ways. It's just a different switch for Scalia.
I guess I have two things to say. The first is I'm not a big Scalia watcher. I don't read all his opinions. I can say that I have read Scalia's writings about how statutes should be interpreted, and to be polite about it, it's hard to square his approach in his writings with what he does in the UR case. As I pointed out, there's a point at which he's not even willing to look at the words of the statute, and that would seem very peculiar for a textualist. I think you'd agree. Now, I think I have to take issue to some extent with the argument that Justice Scalia's opinion cuts back on Massachusetts versus EPA. Massachusetts versus EPA said that the general definition of the term air pollutant was so broad that it included greenhouse gases. But nobody argued that that broad definition applied to the PST program. And the reason nobody argued that was that if you took that position, the PST program would regulate not just regulated air pollutants, but would regulate unregulated air pollutants, would regulate substances, in fact, that pose no danger to public health or welfare. 35 years ago, EPA rejected that interpretation, and EPA read the term air pollutant in the PST provisions as meaning something other than the general definition of air pollutant enunciated in Section 302 of the Act. Instead, EPA said the term air pollutant in PST means only pollutants regulated by the agency under the Clean Air Act. Nobody argued, except in Justice Scalia's mind, that this definition in the general definition of air pollutant in the Act governed in the PST program. As I say, 35 years ago, EPA rejected that, and EPA was consistent with that in its opinion in this case.
Thanks. So shifting a little bit to the Clean Power Plan itself and what it means for EPA, Professor Freeman, you noted that EPA should provide a limiting principle in identifying emission reduction measures that would not be permissible. And so I was wondering, do you see that being a cost basis, or are there other approaches that you think EPA should put out there, given how far they have gone with the building blocks themselves?
Well, again, this is one of these things that Richard and I have discussed extensively and presented extensively. I think EPA has to find a way to suggest that there is something special about the electricity grid that is unique to the power sector and therefore can't extend to other industrial sectors, that allows EPA to consider a best system of emission reduction in the way that it has, to count things outside the plant site itself, because uniquely in this sector, reducing emissions from other activities can affect the emissions at the site. That's just not true in other sectors. The problem is that by selecting end-use efficiency, that is, the capacity to reduce demand for energy, to count that as a lever you can press on to reduce emissions from a source, that's an open gate. That's where the boundarylessness comes, because you can imagine many, many, many kinds of demand reduction strategies that could be quite intrusive into people's lives and into individual liberty that would ultimately have the salutary effect of reducing demand from coal-fired power plants. And drawing that line on the theoretical limitlessness of that one strategy, I actually think it's impossible. I mean, I actually think it's just very difficult to imagine a legal principle mandated by the statute that would give you a line where you could draw that says we mean some kinds of energy efficiency and other kinds. Now, I perhaps shouldn't have said the word impossible, because I do think there's some potential in one avenue. And that is to say that a limiting principle here could be only measures you can take that can be integrated into the grid, demand response strategies and energy efficiency that will reduce demand, that can be integrated into the grid, that would be consistent with all of the particular requirements of the electricity grid, ensuring that it's reliable, ensuring that it's balanced, ensuring that it needs to operate the way it operates, and that regulators have approved, regulators other than EPA, state regulators, energy regulators, and FERC, the Federal Energy Regulatory Commission. You might be able to suggest that there's a limiting principle by virtue of what the market will approve as energy efficiency that could be utilized and what regulators would approve. And if you combine the market, That is, what kinds of efficiency will actually be able to be integrated into the grid without disrupting the system. And regulators who have their own prerogatives, you might be able to say, it's not EPA that has unlimited discretion. We're limited by what the market and the regulators will approve for energy efficiency. I don't think that's 100% satisfying. I still think it's potentially too broad, but it's moving in the direction. So I think they have their work cut out for them, and it's a good thing that they also have an insurance policy, which is the severability clause of the rule.
Thanks. Of course.
Just for people looking at the Clean Power Plan, I think the Homer case is very important, the way it approves of the EPA looking at equitably and really functionally and pragmatically allocating pollution burdens in a way that arguably ends up being cost effective and fairly fair. But I think this case, although the UARG case is problematic for reasons we said, when the majority says in the 17 pages of limiting power, you need to look at language and context, you need to think about the expansive power granted, there are problems to it, but in the Clean Power Plan, you're dealing with Section 111D, and the language there has a very interesting cross-reference to Section 110 of the Clean Air Act. And for you Clean Air Act buffs, doesn't get better, does it? But for you Clean Air buffs, the Section 110 is the state implementation plan process, which is effectively a bubble over each air quality region. And so 111D explicitly calls for a procedure similar to 110, which is effectively calling on states to think holistically as though there is a bubble. I mean, that's explicitly what the cross-reference does. So the kind of language Professor Freeman is mentioning of thinking about the power sector as unusually integrated and the Clean Power Plan giving the states the ability to think about all the different ways in which pollution can be reduced through various energy demand response measures, distributed energy, and the like. I think there's actually a good contextual hook in 111D and 110, and the UARG case, handled by a very good advocate, can emphasize that, talking about looking at language and context and really use that language. Now there's the counter language, which talks about expansive power and reading new meaning into a statute, which is a problem, but I still think that this case has value for both sides on that.
I know we shouldn't all answer every question, and nor should we answer it twice. But just quick, cost is a limiting factor. It's in the statute as something EPA must consider, and so are energy requirements. So it's not that EPA can do just anything. The problem is cost may actually not work as a limiting principle on energy efficiency, which is often the cheapest thing you can do to reduce power demand. So there are problems relying entirely on cost as a limit.
I just quick, Bill suggested is a way an opinion could be written by a court that was favorably predisposed.
Yeah.
That's different than saying we have a court that's favorably predisposed.
Of course.
So one other Clean Power Plan question. Megan, you talk about a storyline for the Clean Power Plan being that EPA has designed a sensible program that takes into account cost effectiveness and historical state action to address the complex problem of greenhouse gas reduction. Another reaction that's happened from stakeholders is criticism of the Clean Power Plan because it doesn't take into account early action. It takes what states are doing and pushes them farther. So for states that have done a lot, they continue to need to do that. And for states that have traditionally a lot of coal-fired power plants, the building blocks don't require significant reductions in those. Do you think that context is problematic for EPA, and are there ways around? And EPA may try to address it as well. But
Great question. So first, just a couple design notes about the Clean Power Plan. So it's a rule that EPA developed with state-specific targets. So each state has to reduce the emission intensity of its own electricity sector a certain amount by 2030. And the way that EPA came up with these state targets is that it took this sort of complex model and it plugged in a lot of assumptions about baseline conditions, and it plugged in a lot of assumptions about different emission reduction measures. So things like making coal power plants more efficient, or replacing coal with efficient natural gas plants, or installing new renewable generation capacity, or doing demand-side energy efficiency. And in this model, EPA made a lot of assumptions about things like growth rates and capacity factors and all sorts of technical assumptions. And then there's a lot of stuff that EPA didn't consider in this model about how resources are really dynamically dispatched to the grid, and how making changes in one area of the electricity sector can have ramifications in the other area. So the electricity sector is very complex, and this was just a model. But EPA used this model to generate a target for each state. And it's really tempting to look at the 2030 targets for each state and compare them to the existing emission intensity of the state and say, wow, State A has to do a lot, and State B, it doesn't look like they have to do a lot at all. But it's actually very complex to compare a 2030 target to what's happening right now, because there's a lot of other things going on in the electricity grid. We have renewable portfolio standards that are increasing over time. We have natural gas prices that are posing a lot of competition for coal power plants. We have really increasingly more stringent controls of conventional pollutants that are causing a lot of coal power plants to retire before 2030 anyway. So anyway, just as background context, it's really not such a simple thing to look at the 2030 targets for states and really determine if that is super stringent, and to determine the relative stringency across states.
And to some extent, don't the targets give credit for early action? For instance, one of the things that the proposed rule calls for is for states to strive to have natural gas-fired units be the base loaded units, be the units that operate first. And it seems to me that the extent to which a state's already done that, the state has that much less to do than it otherwise would have had to do. The same with renewables. To the extent to which a state's already taken action on renewables, the less it will have to do under the Clean Power Plan. Am I missing something major there?
No, I actually think that a more nuanced critique, which some states are making, would say that the Clean Power Plan actually takes it pretty easy on the real early mover states like California. So if you look at the projections from California's Air Resources Board, they'll show you that the Clean Power Plan isn't going to make any difference through California. Their business as usual policy is already below
Vermont
the
doesn't have to
target.
do anything,
And
right?
Vermont
doesn't have to do anything.
They have no plants that are subject to this rule.
I think the early action critique, though, comes from the interaction for Building Block 2 and Building Block 1. So it's not that the states like California don't have to do more, but the critique from companies that have done something is that if you're in Kentucky, you don't have to do that much because there isn't a lot of natural gas that they can push out
right.
to 70%.
So the rule makes some assumptions about if states are really dependent on coal, that they might not have this great capacity to construct really efficient natural gas plants. And that comment has been heard by EPA. And EPA has requested a lot of comments on the design structure underlying its rules. And I think it's very likely that when the final rule is proposed, this is just a proposal, so when the final rule comes out in midsummer, that the design of this rule is going to look a lot different than it does in the proposal, even in terms potentially of the exact state targets.
Yeah, and one way they could do that is assume that states can go in a regional market, that even though they may not have a lot of natural gas capacity in their own state, that there are other capacity elsewhere on the grid. At the moment they've said states, you deal with it within your own state. If they change and say, no, you actually have to, Kentucky, you have to think about things you can go on the grid which are outside your state with natural gas renewable, then they could end up lowering a bunch of states.
But I just want to say something really provocative, which is this doesn't matter. You know, this sort of doesn't matter because the court's never going to get this. Nobody's going to explain this to the court properly. And they're going to go say stuff like, what about the light bulbs? Which is always what they say when they think about the energy sector. And I'm not being facetious. The Chief Justice literally homed in on light bulbs in oral argument in the UARG case to ask about whether EPA is not really, under its authority under the PSD program, going to demand that people do something about their light bulbs, are they? That's not what they're supposed to do. They're there to regulate pollution. And there are light bulbs, and there's pollution. And this, to me, suggests that the court, many on the court, and I don't think that the Chief Justice is alone, think that EPA is a pollution regulator. They don't think EPA is an energy regulator. And they're going to be bugged by the idea that the EPA has veered out of its lane and has decided to do energy policy and is telling the states what kind of energy mix they have to have. I think that is, as a narrative, very powerful and way more important than all the smart stuff everybody's saying about the design.
Oh, completely. And I think that's exactly the argument that we were making in our essay, was that it's really going to come down to the narrative that EPA can tell. And can it tell a compelling narrative as to why this rule is so essential to reduce greenhouse gas emissions from the electricity sector, which has all of these unique and particular features.
I just wanted to point out that it's very hard to be a pollution regulator without directly or indirectly being an energy
That's
regulator.
what EPA has to convince the court of, that you can't, when you're an air pollution regulator, you necessarily are affecting the energy supply. It's true of the sulfur trading program. It's true of the MATS rule and all other hazardous air pollution regulation. It always hits the power sector hard, and they always have to choose to comply through a variety of steps, which have always included fuel switching. This is absolutely the same thing they've always done. Blah, 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 more of same, not extraordinary, not unusual. I'm not saying it's possible, but I'm saying that's what the argument has to be.
But I would say that we worked with 6 companies that submitted comments saying that exactly thing, that this is what they do, they know how to do it, and they take runtime restrictions, and this is what they do.
I was just going to add that for you court watchers, that one of the interesting changes in how people are arguing before the Supreme Court is the use of amicus briefs in recent years. And so what Jody is saying is something you'll find, that there will be, especially on the attacking of regulation side, you tend to have, I'd say a very predictable 5 to 8 prominent, very known anti-regulatory conservative think tanks, and then there's often many more, but there are like 5 to 8, especially the Chamber of Commerce and a few others. And what they tend to do is decide on a few simple catchphrases of what they view as the big problem. And so light bulbs were the problem in this one. In a case called Rapanos, they were talking about regulating dry riverbeds, and they had certain kind of rhetorical devices they used again and again. And on the other side, on the environmental side, because you tend to have to support these kinds of arguments with a lot of history and explanation how regulation works, on the pro-regulatory side, you'll find is the environmentalist camps will typically divide it up where different people will put before the court a whole bunch of important history about how a sector works or how a particular industry works, the history of a particular body of regulation. So you have very different strategies before the court. One side is the powerful story and the simple heuristics and the simple catchphrases, and the other side is kind of more contextual, pragmatic, and historical.
It's like the Democrats and Republicans. Democrats
but it's
lose
true.
because we're all about complexity and it's all difficult, and the Republicans are like, war on coal.
Yeah. No, but it really is. But you should watch this. It's really an interesting change in how the two sides in recent years have been battling. Is quite predictable, and it tends to break down that way. But it works before the court. The justices, they'll come out with their questions, and when they've read it in 10 amicus briefs, they just think it's true.
And the other thing, actually, the best amicus brief on industry side in the Herzog case was by the energy-intensive manufacturers. It was written by Ron Tempest, and it's a wonderful, wonderful lawyer. And when I read that brief, I was worried. And that's the one which you see reflected in Scalia's opinion, because they said, look, they're trying to basically use greenhouse gas emissions to tell us how to run our manufacturing facility, to save energy everywhere. He said that can't be what the Clean Air Act is about. And you see that dichotomy, air pollution versus energy efficiency. You see it in Scalia's opinion for the court, where he says, you could do this, but you would never do that. And actually, the truth is, EPA's always done it. The two have always been so inextricably linked. When you are more fuel efficient in lots, you actually reduce your pollution. But the court still sees it as a narrative as two very different things.